Mrs Kelly.
Thank you, Mr Speaker. Mr Speaker, I'm pleased to rise to move the second group of amendments and to welcome this opportunity to outline the SDLP amendments regarding domestic violence. And I'd like to begin by putting on record my thanks to Women's Aid Northern Ireland for their advice and insight, for the tremendous work they do helping victims of domestic abuse, and for their help in tabling these amendments. I would also like to express sincere gratitude, in particular to Aoibhinn in the Bill Office, for her hard work and support in helping to draft these amendments, and also, of course, our own party policy staff. Domestic abuse can affect anyone, regardless of socio-economic status, gender, religion, age, or race or sexuality. However, Mr Speaker, whilst there are increasing reported incidents of males suffering domestic violence and others in same-sex relationships also suffering domestic violence, nonetheless, the vast majority of victims of domestic abuse are in fact women, and the perpetrators are men. Domestic abuse thrives on happening in private, but it is a matter of public concern. On average here in Northern Ireland, each year, 5 women lose their lives to domestic violence. PSNI statistics indicate that there were 27,628 domestic violence incidents reported in the year 2013-14, and 12,720 abuse crimes. In fact, Mr Speaker, every 19 minutes an incident of domestic violence is reported to the police. That works out, on average, over 400 incidents per week. And it is estimated that 1 in 4 women will experience domestic abuse in their lifetime, and it accounts for approximately 1/5 of all recorded violent crime in Northern Ireland. I repeat, 1/5 of all recorded violent crime is committed by someone the victim should be able to trust, often the place the victim should feel safest of all, their home. Victims and survivors of domestic violence may endure the most horrific sexual and physical violence. Also, according to police statistics, on average, there are 35 previous experiences of domestic violence by one victim before they actually make that call for help. In England and Wales, it is estimated that 2 women die at the hands of a former or current partner. Women, for example, like Claire Woods, whose murder triggered the introduction of Clare's Law in England and Wales. A domestic violence disclosure scheme we want to see established in Northern Ireland. I think we have to ask ourselves, why should women here not have the same protections afforded to them as other regions in these islands? I think it's fair to say that the majority of people now recognise that domestic abuse is not exclusively sexual or violent. Domestic abuse can be psychological, involving controlling and coercive behaviour, and it can involve financial manipulation, denying someone economic independence. This is intended to make someone feel utterly hopeless and worthless. Mental and emotional torture that reduces a person to a shadow of themselves is abuse in itself, but as well as that, it often precedes violent and physical abuse. Indeed, Mr Speaker, one would say it is characteristic of the grooming that many women experience before that first physical attack. And whilst attitudes around domestic violence have progressed, they have not progressed far enough. When faced with incidents of domestic abuse, many people ask, why doesn't she leave, rather than why does he do it, or even how does he get away with it. Only last week, Mr Deputy Speaker, I dealt with a case in my constituency office of domestic violence, and I'm sure each of you in your own constituency offices have had to help victims either get rehousing, to get psychological counselling, or to help with their financial circumstances. We in the SDLP saw this bill as an opportunity to introduce provisions that would provide greater protections for those suffering domestic violence and those at risk of domestic abuse. Our amendments would see the introduction of domestic violence protection orders and notices, and indeed Clare's Law in Northern Ireland. Our first amendment, Amendment 21, was drafted to ensure that prosecutorial fines could not be issued in lieu of appearing in court for a domestic abuse offence. Not only would this belittle the seriousness of domestic abuse, it could also harm someone who is a victim of financial abuse, who would ultimately face this cost and would make the implementation of a disclosure scheme more difficult. If the Minister can assure us that domestic violence offences will not be subject to prosecutorial fines, we are satisfied that this does not need to be included on the face of this bill.
Amendment 6, I think.
That refers to Amendment 6, the first in the group. To elaborate on our other amendments, a domestic violence protection notice enables police to ban a perpetrator from returning to their home and from having contact with the victim of domestic abuse for up to 48 hours after a... Yes, I will give way.
And I come from this from a sympathetic point, so I just want to tease out an issue that I think is relevant in this, particularly when we talk about domestic violence protection orders. I know that the wording in the amendment is on reasonable grounds, but this is quite a big power that allows the police to potentially remove somebody from their home before they've been convicted of any offence. She's rightly pointed out that not all domestic violence is sexual abuse or even violent abuse. So I was wondering where she sees the threshold or the need for any sort of evidential base for the police to issue such an order, and how do we ensure that these sorts of things are not abused by people who potentially would be in a difficult relationship that is not actually suffering from domestic abuse, but it could potentially be abused as a way in which to remove a man from a house?
Well, thank you for that intervention, and it is something, of course, which has been piloted, the introduction of these schemes in England and Wales, in particular in 3 areas in England, and there is indeed a very helpful Home Office report available which actually looked at the schemes and evaluated them, and in actual fact I think there was up to almost 6,000 such orders applied for, but only 2 were turned down because the constable who is called out to the scene has to actually get the domestic violence protection order approved by a senior officer, that is a superintendent, and they would only be used where there are no other enforceable restrictions available to the police. So I do believe there are safeguards, and it ought not to be willy-nilly. In addition to the evaluation report following the pilot schemes in England, it was recommended that there would be training provided for police officers and indeed magistrates in applying such schemes, and it would be, I'm sure, my hope and the intention of both the PSNI and the Department of Justice to ensure that such training was provided. I have spoken to police officers in the preparation for today's debate and in tabling the amendments, and the police would welcome having these resources available to them to better protect women in society. So I'm satisfied that there are adequate safeguards. And the domestic violence protection notice lasts for 48 hours, and then there would have to be application to the magistrates' court, which then can be applied for a notice for up to 28 days. And the whole intent behind both the notices and the orders were designed to support victims who may otherwise have had to flee their homes, and to give them breathing space to access support and consider the options available to them. If it helps members to set it in some form of context, in the year 13-14, over 700 families had to be rehoused as a consequence of domestic violence. The introduction of such orders as these would mean that the perpetrator is the person who has to leave the home and not the family. And in addition to that, it does allow that time for the victim to have other support, whether it's Women's Aid or other support services, to help them to make the decision that is right for them in relation to their future well-being and that of their family. And indeed, in 2010, the Criminal Justice Inspection undertook a review into the way that domestic violence and abuse cases were handled by the criminal justice system in Northern Ireland, and it made a number of recommendations, including the introduction of the domestic violence protection orders and notices. So it already has the support here in Northern Ireland of the Criminal Justice Inspectorate. In March 2014, a domestic violence disclosure scheme, more commonly known as Clare's Law, was rolled out across England and Wales. In February 2009, Clare Wood was violently murdered by a former boyfriend, George Appleton, who had previous convictions for the harassment and assault of former partners. Ms Wood had contacted the Greater Manchester Police in the months leading up to her death to report that Appleton had caused criminal damage, harassed her, threatened to kill her and sexually assaulted her. Clare's Law enables the police to disclose information to an individual who has asked police to check whether or not a new or existing partner has a history of domestic violence or indeed a violent past. Police will subsequently consider disclosing information if their checks find this individual may be at risk of domestic violence from their partner. It was reported in January 2015 that 3,760 applications for disclosure had been made in England and Wales, and that at least 1,335 warnings have been issued only 10 months after the scheme was launched. And we want to see a similar scheme launched in Northern Ireland to make it harder for perpetrators to re-offend. I am very pleased to report, Mr Deputy Speaker, that following consultation with all of the parties, that a number of members have indeed expressed their support for the intentions around these amendments. Implementing DVPOs and DVPNs would not only make a real difference to the lives of people affected by domestic violence, which include, I should remind the House, children living in these homes. And there are some 11,000 children, local research has found, living with the reality of domestic violence every day here in Northern Ireland. And I think having this scheme available to us would help to move the social perception around domestic violence on. I met, Mr Deputy Speaker, with the Justice Minister on the 21st of May and had a very productive discussion. I was pleased to find that he was supportive of these amendments, but was advised that the wording of the drafting requires some further tweaking. Therefore, his officials advised that the introduction of Clare's Law will require a public consultation and that he fully intends to do so. In order to give the Department time to come back and meet these principles, I have agreed not to formally move these amendments at this stage if we receive a ministerial assurance that amendments regarding domestic violence protection orders and domestic violence protection notices will be introduced at further consideration stage, which I expect should be forthcoming. Likewise, I will not move the amendment regarding Clare's Law if we receive a ministerial assurance that a public consultation is being brought forward. Moving on to the other amendments in this group, which relate to the prevention, protections and disclosure relating to vulnerable groups, I will speak very briefly on these amendments, as I am sure they will be spoken about in detail by the proposers, the ministers and members of the DUP. The SDLP are largely supportive of these amendments. Amendments 7 to 10 relate to Clause 33, victim statements. These proposed amendments will extend the scope of a victim statement in certain circumstances to include how a victim's family has been affected, and the SDLP are supportive of these amendments. The SDLP are also supportive of Amendments 11 and 17 in relation to disclosures. Amendment 11 inserts a new clause on disclosure of purposes of victim and witness support services and victim information schemes. Amendment 17 also inserts a new clause in relation to the Department of Justice disclosures to the Disclosure and Barring Service. Both I and my colleagues in the SDLP are supportive of the DUP amendment, which would be similar to Sarah's Law. The amendment would provide guidance for agencies to consider disclosure of information to relevant previous convictions of any specified sexual or violent offender. where it is necessary to protect a particular child or children from serious harm. I am sure that the proposers of this amendment will speak to this in much more detail, but this is an amendment which we in the SDLP will support. Amendment 68 proposes to insert a new schedule in relation to witness support services and victim information schemes. My SDLP colleagues and I support this amendment. Mr Deputy Speaker, I would like to close by returning to the SDLP amendments in relation to domestic abuse. I have been extremely heartened by the support the Department and other parties have expressed for these amendments and look forward to working with other members in the future to tackle domestic violence and abuse in our society. I truly believe that DVPOs and DVPNs and Clare's Law will help to bridge a gap in how we tackle domestic abuse. Thank you, Mr Deputy Speaker.